Who here feels prepared about the GDPR? Is quite comfortable? Excellent. Let me tell you why. Until 24 hours ago, I thought I wasn't going to be anywhere near here. I was going to be 200 miles away in the north, in Leeds, while my colleague Dawn Monaghan would be speaking here to you. And then yesterday lunchtime, I got the news that she couldn't make this and got asked to attend. So kind of that was the surprise. The preparation was fortunately done because I'm speaking at the event, or spoke at the event in Manchester, and also will be speaking next week, touch wood, in Birmingham. But to get you an idea and make you think a little bit, if you think about preparation, some of you are going to find yourself like that with the GDPR. You'll have an understanding of roughly what you expect. You will still see things that throw you. So what we try to do when we're doing the health service guidance is not be comprehensive about everything, but to point people in the right direction so that the basics are done. So if they do get caught by surprise, like I was yesterday lunchtime, then they'll have a good idea how to react, what they need to do. So what I'm going to set out this morning is, or into this afternoon as we turn 12, is the route and the preparation work that's already going on within the health sector, led by, as Tim said, NHS England and also NHS Digital. And just to confuse matters further, I work for the latter and will be moving to the former in a couple of weeks. So, a bit of confusion all round. And as Tim said before that, I had spent 13 and a half years at the ICO and worked all the way through data protection and freedom of information and back again from casework, policy work, tribunal enforcement, etc. So I've got a reasonable understanding of the current law and have half an idea where things are going in the future, but no better than anyone else. So that's the National Working Group. I'm currently chairing it on behalf of Dawn. We have a wide range of organisations, not just from within the health sector, but from outside as well. Tim has attended recently representing the LGA. And it's really about the health and care system in England and its preparation, both for the GDPR and also the wider changes being made with the Data Protection Bill, which will become the DPA 2018. We think we've captured most, if not all, major health bodies and also representative groups from the smaller organisations within the health. And we've got most of the people involved either helping us with the drafting of stuff or also reviewing it. But of course, data protection reform is not just the GDPR. You've got the Data Protection Bill. We've got to think about the EU Law Enforcement Directive. Okay, it's not day-to-day relevant for work within the health sector, but we have to be aware of it. It's part of the context we need to understand. And that environment we've got within health is already complex enough. If I give you a short list of some of the issues we have to think about on a day-to-day basis, we have to consider the common law duty of confidentiality in relation to the provision of direct care to patients, also secondary use of such data. Got the Health and Social Care Act 2012, the NHS Act 2006, the Care Act 2014, the Gender Recognition Act 2004, Human Fertilisation and Embryology Acts from 1991 and 2008. And then, of course, we've got Freedom of Information, Digital Economy Act, Computer Misuse Act, and the Human Rights Act. And that's before we get anywhere near statutory codes of practice, etc. So there's an awful lot of stuff that we have to consider when we're going through that within the health sector. Where we are now in terms of preparation, we know the GDPR is pretty well done deal, as it says on the tin. We think we know where the Data Protection Bill is going, and it should have gone to the Commons about now, but we know there are going to be changes made. We know there have been amendments put in by the House of Lords, which the government has said they are minded to try and overturn. So we think there's going to be a bit of political footballing around. We also know with the GDPR, it took 4 years of negotiation, discussion, and refinement until you ended up with the final version. The Data Protection Bill was published in September last year, and the plan is to have it as an Act of Parliament by the end of May this year in time for the GDPR going live, for want of a better phrase. So the GDPR, we had a lot of time to understand what was going on and its direction of travel. The Data Protection Bill, a lot less so. And it's quite a complex piece of work, over 200 pages of it, and some significant changes, some stuff that will directly impact with the health and care area, such as a criminalisation of re-identification from de-identified data sets. Now, sometimes within the health and care sector, you will get GPs who will go through data which is anonymized, pseudonymized, call it what you want, but recognize that there are people, and this is about their patients, but not knowing which patient it is, and will request for re-identification because they have seen something they need to investigate further with that individual. So there is complexity we need to deal with within the data protection bill. So as I said, GDPR, we're pretty certain what's involved. Yes, we have to wait to see how it's interpreted, how the regulators deal with it, both European level and the UK level, the ICO, but we also have to see what the final outcome is going to be with the data protection bill. What will the actual final Data Protection Act 2018 look like? So we're working in that field of complexity I mentioned earlier, and also trying to juggle where the data protection bill is going to end up, where some fairly serious provisions for us, what they're going to mean in practice. So that's our publication schedule. We are behind where we would like to be because we've had it reviewed until the point of there is no further review that can be done because every word has been combed over. We have had input from Department of Health Legal. That has been actually quite useful, but it has slowed down our publication, which means that we're going to see a lot of material published in the next month or so. And just before I came into the session, I've been finalising some drafts, which I hope to have available later this week. What we intend to do is to publish on the Information Governance Alliance website. There is a slight hiatus because ownership of that is being transferred from NHS Digital to NHS England. But as soon as that guidance is good to go, it will be made available and cascaded and published on the LGA website as soon as possible. You'll notice there's a piece on the second to last in the left-hand side, pseudonymization. I don't think that will be published in the next month or even the next couple of months. This is an important piece of work for the health service. A lot of the data that flows around health care is pseudonymized. There are implications within the GDPR for existing approaches to pseudonymization. You'll be aware that GDPR actually recognizes pseudonymization as a good mitigating technique in terms of reducing the risk around the use of identifiable data. But we need to understand, and again, working with the ICO, what that means in reality. Does it mean that somewhere there is a line between de-identified but still personal data and de-identified and outside the scope of the law? So there's a lot of work yet to be done with that, and that's why I think pseudonymization in the next couple of months as a piece of guidance is kind of optimistic. The IGA will not be the font of all knowledge. The NHS Digital, when I wrote this, did plan to publish a checklist linked to the current IG toolkit, which is used in the health service. That plan has changed within the last week. The checklist will now be published as part of the IGA suite of guidance. Secondly, there's also some guidance that's come out from the Health Research Authority, which has been very much written for the research community. It's kind of a bit heavy and a bit technical, but also it may give you an insight, especially if you are involved in doing work around research and care and research and healthcare and research. But they also exist if you want to look at them as well. And of course, you've got, and we rely on it a lot, the ICO's, what I call the ICO's core guidance, the 12 steps, the current guidance, and as they develop their own thinking around the GDPR, and also the Article 29 group develops its thinking, then we feed that into what we're doing within the health sector. And then once we've done that, we need to consider some of the statutory stuff that we are responsible for. The NHS has a code of practice on confidentiality, which hasn't been updated from 2003. We know we need to update it, and that's work that Dawn Monaghan will be taking forward in NHS England in the near future. But we can't come to clear lines again until the ICO have worked through an awful lot of stuff. And we recognise that Stacey and her colleagues are under a lot of pressure. They've got a whole host of issues to work through in terms of both the GDPR and the data protection bill. And you've got to remember, they're not just doing it for local government and for health. They're doing it for all the public sector and all the private sector. And if you think there's about 450, even 450, numbers have increased since I left, but you think 450 people work on all they do across the entire United Kingdom. It's not a lot of people to do an awful lot of work. So we know there will be delays in the system in terms of getting some of this detailed stuff sorted through. We know it's there to be done, but we know it will take time just because of the resource constraint that exists. And then the other thing we have to bear in mind and integrate this with is what's called the national lockdown. You may remember that the Secretary of State for Health, Jeremy Hunt, made a commitment to the public about 5 years ago now, that if you did not want your identifiable data to be used beyond your own care purposes, then it wouldn't be. It's a simple statement to make, but actually quite a complex piece of work involved making it a reality, giving you, as members of the public, as patients, the choice to decide if you want your identifiable data to be used for what they call secondary uses. And that's going to be launched in May this year as well. So there's, again, awful lot of intertwined things going on across the health sector which will impact into local government. And we're aware of that. We're aware it's not a perfect picture, but we're also aware that, we have to work with others. Everyone's constrained, resources are stretched. We have to make the most of what we can do and be realistic about it. Should you be worried? Who is worried? Hand's gone up there. Why? Oh, so you're worried for, I thought, okay, so are you worried about the GDPR? Oh, okay, fine. I mean, there is the sense of, oh Lord, what does this mean? And there's a lot of hype and a lot of, frankly, rubbish out there. And the message we're getting across to the health services, ignore the rubbish, look at what we're doing at the centre, even if you've got no specific guidance that covers specific detail, take the general guidance, take the ICO's 12 steps, take the stuff that the IGA will be publishing and making available in the next week or so, and use it to develop a plan to bit by bit take you from where you are now, and I'm going to take it, everyone's going to be compliant with data protection, into the GDPR. Because if you actually look at the GDPR, all it is doing is taking the existing data protection regime and beefing it up. A lot of stuff that we now take as good practice in the data protection regime, such as privacy impact assessments, will become, for a large part, compulsory with the GDPR, with the data protection impact assessments. But it's not a radical change. It takes the existing way of working and gives it more strength. So changes have to be made, but they shouldn't surprise you. It's not coming out of the blue. As I said, there are unknowns with the data protection bill, and there's going to be some complex stuff around that. But in terms of the big picture, that, again, I don't think will make substantial changes. So if you're meeting your present obligations or there or thereabout, and you follow good practice, never gold plate it, never look for best practice, just do what you can, know your organisation, know where your information assets are, know how these are recorded, know and make sure you've got your transparency in place. Beware of the increased rights for data subjects, especially if you're using explicit consent, or especially if you're using consent. And then bit by bit, move yourself and your organisation into a point where you are comfortable with the GDPR. There are no experts. Nearest you've got is Chris Pounder, who spoke to you earlier, and who knows the provisions inside and out. But no one has seen the GDPR work yet. We don't know how, as I said, supervisory authorities, courts, etc., are going to interpret it. So there is no right way of doing it. All you can do is get yourself prepared for what's coming. It's all about proportionality. It is like data protection as it currently is, shades of grey, and a lot of them. And as a last point, there always will be those unresolved issues. You'll always hit something new or different. And that's just the nature of the way we work nowadays. But even so, as I said, the ICO are not expert. They're developing how they will approach the subject. The key to me, and coming from my experience across the years, is you might not see the perfect answer in what's out there. But if you justify what you're going to do rationally and reasonably within the constraints of what you know, you're in a reasonable place. Not saying it's a perfect place, not saying you'll be absolutely right, but if you're proportionate about your approach to an issue and you can justify it, then you're probably in the right direction. And again, this is a message we're getting across to the health service. We don't want the panic. We don't want them running out to get expensive consultants, because you have to remember these expensive consultants started looking at the GDPR probably about 12 months ago, and frankly no less than most experienced practitioners. You have some very honourable exceptions, and Chris Pounder has been around data protection longer than I have. has been involved in many, many issues. But there's a lot of hype and panic out there, and the message we're getting across to the health service, the same message I'll give to you now. Don't panic. Just approach it. Things will have to change, have to be done, but there's a lot of help out there for you. And these are a couple of quotes from Elizabeth Denham's blog in the last couple of months. It will be ongoing. There will never be perfection. It's unlikely you will see massive fines immediately. I know there's a lot of hype about it. A couple of reasons for that. The ICO has always been a proportionate regulator, but also the ICO, as I said, is a small body. It cannot pick fights with everyone, even if it wanted to. The other thing is, if the ICO goes from fines now, where I think the largest fine has been £400,000 for TalkTalk's lack of security, and then starts to take fines into the £4 or £5 million without either good reason or due escalation, it's going to be subject to judicial review. Again, they're going to have to adapt in a proportionate approach. And the final quote, well, it sums up the ICO, but it also sums up the message that we're getting across to the health sector. Yes, things are changing, but if you do your due diligence, your homework, your preparation, you'll never be perfect, but it'll be on the right lines. And again, that's how the regulator in this country has always approached the subject, always encouraged that good practice, always encouraged people who are trying to do the right things. Where it has acted and acted strongly is where the advice and the guidance has been ignored. So if you are preparing to ignore the advice and guidance, both from us, and the LGA we don't really mind too much, but also from the regulator, who might have other thoughts, then yeah, you can expect the worst. But for everyone else who does their due diligence, their preparation, you should be in a reasonable place. There is no need to be worried, no need to panic. And so that's the message that I send to you, but it's also the message we're putting out across the health service. Thank you.